Hi, thank you for reaching out to Pasternak Appel for your estate administration needs in New Jersey. We wanted to give you some information about the estate administration process so you have a better understanding of what will be going on with your matter. So first, let's talk about the different types of administration. So if there is a will, the will be probated in the surrogate's court. You may be referred to as the executor if the will designates you as the executor. In that situation, the estate is referred to as a testate estate, and that the decedent died testate, which means with a will. If, on the other hand, there was no will, then and you are appointed to administer the estate, or you will be called the administrator. In that situation, the estate is referred to as an intestate estate, and that the decedent died intestate, which means without a will. How does the probate procedure work? Well, it's a little bit different depending upon whether or not there was a will or there was no will. So if there was a will, which again means that it's a testate estate, if there are probate assets in the estate, then when the will will be probated soon after the decedent's death. You need to wait 10 days before you can move to probate a will. In order to probate a will, you need to have the original will, any codicils, which are amendments, the death certificate, and then you would need to attend the surrogate's office in the county where the decedent resided at the time of his or her demise. If the original will is in a safe deposit box, you should be able to enter accompanied by a bank officer to remove the will. If the will is not self-proving, it will also be necessary for somebody who was a witness of the will to appear at the surrogate's office, or if they can't because they're from outside of the jurisdiction, then they would sign a notarized affidavit that would be filed with the surrogate's office acknowledging that their signature in the will was theirs and that they were a witness to the original will. If somebody dies without a will, which is called intestate, then the next of kin would apply to be appointed administrator, and the New Jersey intestacy statutes will determine who receives the net assets in the state. It's important to note that if somebody dies intestate, then they are most likely going to be required to post a bond, and they would have to qualify for posting a bond where they look at your credit history and your criminal history. Most cases where there is a will, they usually waive the requirement for a bond. The short certificate, what is that? So as I mentioned previously, there's a 10-day waiting period from the date of the decedent's death before the surrogate's court will issue this short certificate, which will indicate that you've been appointed as an executor or administrator. This time period allows for someone to challenge the validity of a will by what's called a caveat. If someone challenges the will or otherwise raises any dispute, the surrogate's court may no longer proceed with the probate, and no one is authorized to administer the estate until the probate court resolves the dispute if it cannot be settled. In New Jersey, residents have 4 months, non-residents have 6 months to file a lawsuit to challenge the will. In order for you to act on behalf of this estate, the short certificate must be issued by the surrogate's court. The short certificate's one page with a seal at the bottom signed by the court saying that you've been appointed as the executor or the administrator of the decedent's estate. In effect, you stand in the place of the decedent to administer the estate, pay debts and expenses, and collect and distribute assets. The short certificate must be provided to each bank, brokerage firm, and other persons when collecting or transferring property of the decedent, so you'll likely need multiple original copies. If you are appointed as the executor or administrator, your job will be to identify and manage assets. So you will have to determine which assets are under the estate's control and require probate. Not every asset requires probate. There are certain assets that are transferred outside of probate. So things that have direct beneficiaries, 401k plans, IRAs, investment funds, life insurance, sometimes bank accounts if they are TOD or transfer on death. So you will have to determine which of these goes outside of probate and which of these go direct through probate. You'll have to get a federal tax ID number for the estate, and you'll most likely have to open up a bank account as well in the name of the estate. You'll have to begin to make an inventory of all the assets of the estate, and then you're going to need these for an accounting and a tax return, which we'll talk about in more detail in a little bit. And then you're going to have to make sure to keep all real estate and automobiles insured to make sure that there is no issues with them not having insurance. And obviously, you probably want to keep people from riding the automobiles if possible, but you definitely have to make sure that they are insured. A real estate broker can help you appraise the real estate if you're planning to sell it. No furniture, jewelry, or other tangible personal property should be distributed until it has been appraised. The appraisal will be needed for any required death tax returns and for determining the shares of the beneficiary. And again, if there's any disclaimers that are going to happen, this is the time. So if a beneficiary, including a surviving spouse, decides that they want to disclaim any portion of the assets, this can be done. This is often done when an estate plan intends and arranges for things to be disclaimed because of tax planning and other asset protection considerations. So you also, as the executor or the administrator, have to make sure that tax returns are filed. So you will be required to file all tax returns timely. You will have to file an income tax return of the decedent for the last year of which they were around. So you'll have to make sure that you're filing their income tax return. If the value of the estate is over $13.61 million, then you will have to file a federal estate tax return. New Jersey currently does not have an estate tax return, although it does have an inheritance tax return, and that depends on the relationship of the beneficiary to the decedent. So if it is a child, a grandchild, there will be no inheritance tax, but if it's a sibling or niece or nephew, there would be an inheritance tax. So that's something that is important to pay attention. You will be responsible for making sure those rates, those beneficiaries that would have an inheritance tax applied to them, those taxes are filed. Tax waivers and clearances. New Jersey imposes an automatic lien on real estate, stocks of New Jersey corporations, and New Jersey bank accounts as security for the payment of taxes. The stocks in half of each bank account are frozen in place until the state reviews the inheritance return tax and issues tax waivers. A spouse or lineal ancestor or descendant, which again is like a child, grandchild, can avoid the lien because there is no tax due, right? Remember, I just mentioned that children, grandchildren, since they're kind of in that direct line, don't have to pay an inheritance tax. So they don't have, if they will file a L8 form and a copy of the will, and they will provide that to the bank to show that there's no tax due, and therefore those assets will not get frozen. Another thing that must happen is that creditors and liabilities must get taken care of. So you must pay creditors of the estate in order to avoid personal liability. New Jersey formerly required executors to publish a notice, but you no longer have to publish notice to creditors. But you must pay creditors that are known to you. If a claim is filed against the estate for known or unknown claims, if you did not pay them off, then you could be personally liable. And late claims could expose you, as I just mentioned, to personal liability. So you want to make a refunding bond and release forms, use them against future debt. So we're going to talk about what those are in a second. And properties may have liens that necessitate holding sale proceeds in escrow until clearance is achieved to cover potential debts. Then it comes time to distribute. So how do we distribute the taxes? So after all the debts are paid and the taxes are paid, the remaining assets can be distributed. Usually this is again done only after you have clearance from the New Jersey state tax auditors. Any early distributions require confidence that the estate tax returns can't be challenged. Again, since there are no estate tax returns and only inheritance, if no one is inheriting that's outside of a direct beneficiary, then you don't necessarily have to wait for this clearance. You should reserve some money in the estate for several years just to make sure that there are no unexpected claims. No distribution should be made without the receipt by you of a refunding bond and release form signed by the beneficiary in front of a notary. So if you're going to go give one of the beneficiaries X amount of dollars, you want to make sure that they are signing a refunding bond and release form as well. All New Jersey securities, bank accounts, and real estate will require either a tax clearing notice from the Division of Taxation or an inheritance tax waiver prior to making distribution, as we had mentioned. Accounting. So what is an accounting, right? So beneficiaries will demand or require an accounting prior to accepting any distribution from the estate. So an attorney or an accountant may prepare the accounting. If a beneficiary demands an accounting, then you may negotiate for it to be an informal as compared to a formal accounting. And informal accounting takes less time and is much less expensive than doing a formal accounting. But a beneficiary could demand a formal accounting that would be required to be submitted to the court for approval. Judges may require that formal accountings be paid by the beneficiary demanding it as well. So the accounting basically talks about everything that has gone out of the estate and everything that has come into the estate. So it is important to make sure that you have all of the bank records and all of the financial records so that you can show what has gone in and out to everybody. Again, we mentioned a few times the refunding bond and release forms. So again, before you distribute anything from the estate, you're going to get a refunding bond and release form signed by the beneficiaries, the people who are left to inherit the estate. This form provides that each beneficiary acknowledges their receipt of the share of the estate, releases claims against the executor, and agrees to refund any portion if a claim is made against it at a future date. You can file these forms with the surrogate's office indicating that the estate is closed. So even for small estates, it's really advisable to get these types of forms. And then utilizing professional services. So professionals can be invaluable in estate planning, especially if it's a very complicated estate where there are real estate issues or tax issues. So you may want to consider hiring an estate attorney for legal guidance, or employ a CPA, and leveraging real estate brokers. And then closing the bond. If you were required to get a bond, annual premiums are due for bonds every year until the estate's closed. So to complete the process, you need to file the accounting, refunding bond and release forms, tax waivers from the state, and then notify the bond company so that you don't continue to get billed for a year. So again, this is just a general overview of estate administration in New Jersey. Hope that you found this helpful, and if you have any questions, please don't hesitate to reach out to us.